Okay, well, good morning, everyone. And just remember that this too shall pass. It is the Corporate Transparency Act today, what you need to know and what you need to do, most of all, especially if you are subject to the requirements of this act. We should run roughly about half hour to 40 minutes and have you out of here on time. So thing to keep in mind is that the purpose of the Corporate Transparency Act is the cynic is going to say that it's a information grab, and it's really to get a head start on investigations or potential investigations. I think that's the crux of it. So they get small businesses reporting so that they can have a head start on any shell companies or know where to look. One of the hardest things to begin an investigation is to find initially where things are, and so if they can get some kind of groundwork in place for self-reporting, then that makes it all the easier for the folks to investigate money crimes. And indeed, it is a reporting to the Treasury Department, so the misleading part is that if you look at the Corporate Transparency Act title, many people will intuitively say, well, okay, that applies to corporations, but I have an LLC or I have this other entity here, and but it applies far beyond just simply corporations. So we'll talk about what that entails. So it's to assist the government in any future investigations. That's why it's there. So what the act really requires is to have a certain report kind of filed, or filed, not kind of filed, but the beneficial owner information report. So we're going to see, I'm going to use the BOIR as the acronym as the reference to this. And there's certain terms associated with this that I guess over the years as this applies, we would become familiar with it. But since it's brand new, the application is brand new. It's been around for 2 years saying, oh yeah, it's going to happen, going to happen, going to happen. And then on January 1st of 2024 is when it hit the ground running, and that's when the effective date is. So the reporting company must file beneficial ownership information. So a reporting company is the corporation's form. So basically, the filing requirement is with the FinCEN, the Financial Crimes Enforcement Network of the Treasury Department. So Treasury Department obviously is IRS. And it only applies to small businesses, the private entity of small businesses, not large corporations and not more regulated corporations. So there's exemptions for things like banks and much larger companies. And so if you read some articles, and I just happened this morning to check an article that was in Newsweek a couple of days ago, they do come out and say that this is strictly a focus on small businesses, and you can look at it a couple different ways. I am a small business, so I'm affected by this. I have a corporation, and so I have to report as well. So it's just an extra another thing we have to do as part of being in business. And unfortunately, those who make these rules generally aren't in business. And so, but the good thing is that you can do all this electronically, and it doesn't require any paperwork, filing of returns or anything like that. But you do have to stay on the ball. So a reporting company is anything that is created by filing with the state government. So the actual language is any entity that is a corporation, LLC, or otherwise created by the filing of a document with the Secretary of State or similar office under the law of a state or Indian tribe. So we're in Maryland, and so anytime that we've created a business entity, we're creating it through the State Department of Assessment and Taxation. So that would be the equivalent of a similar office under state law. And so anything that's created that way is something that has to report. The beneficial owner is any individual who directly or indirectly exercises substantial control over a reporting company. So that's the company that was created under state law, or owns at least 25% of the ownership interest of a reporting company. So you're either a 25% owner, you control 25%, or you exercise control over the company otherwise. So a fairly broad and nebulous kind of a standard for beneficial owner. And that kind of leads us to, well, if you're not sure, you probably should report in that way so that you don't get caught up in the wash. So the reporting company is an entity created by filing a document with the Secretary of State or similar office. So it is corporations, LLCs, partnerships. If you create the partnership that way, there can be a common law partnership where you just act as a partnership and nothing's filed, and that conceivably would not apply to you. But if you create a partnership formality with the state, then you would have that requirement. Statutory trust will also be included. A common law trust, one that's created privately, say through estate planning or something like that, that happens to own the company, is not a reporting company in and of itself, but may have to be reported as an owner of the or the trustees of the trust would have to be reported as owners of the company if they otherwise qualify. The company can be domestic or foreign. As long as it registers with a particular state, then it would be considered subject to the Corporate Transparency Act. And as I said earlier, there are exclusions. So companies subject to government regulation or oversight, think banks. Banks are just regulated out the wazoo, so they're not going to be subject to this. And then the very large companies are not going to either. They do enough filing in between with the government as it is, so they feel that they don't need to have them reporting. It's the ones who are smaller and heretofore anonymous corporations that they're looking to learn more. The beneficial ownership test is a couple different ways, and these are all connected by or. So if you read this afterwards, so the individual owns at least 25% of the ownership interest in the reporting company, or the individual controls at least 25%. So owns or controls, and then you pass that test, and then your information has to be reported. If in fact you're not the owner, but you are controlling the company, then you are caught up in it as well, and you have to provide information. Could be a senior officer, individual with the power to remove and replace senior officers or a majority of the board of directors, or just a power over important decisions for the company. And so all of these are open for interpretation. And obviously the government is going to interpret it broadly, and the company is going to want to interpret it narrowly. And at the end of the day, who wins? Well, you can look at it a couple different ways. Even if you, as the small company, win the contest with the government, you might wind up spending $1 gazillion on lawyers and on the effort to do so. And do you really win in that situation? So probably the best way to deal with it, or the least costly, the least disruptive way, would be to say, okay, if we're kind of close, let's err on the side of caution and make sure that we do the reporting, even if we're not sure whether we do meet the control test. So that's beneficial owner. So beneficial owners, there's certain information need to be provided. The company applicant is the person who helps and assists in creating the entity. So in my world, I will often do that for clients who are forming businesses. So we get onto the State Department of Assessment and Taxation website. We do our filings, and you pay the fees, and we're doing it for them. And so I would be the company applicant, or my firm would be the company applicant at that time. So there's certain information that has to be disclosed for that person or that company that is assisting in the formation. So the individual who directly files the document that creates the reporting company. So it would be articles of incorporation for a corporation, articles of organization for an LLC, and any other various documents as well, partnership, anything that would be in place. Whatever gets filed with the state, the person who assisted in getting that done has to provide. So for the law firm, so if I have let's say I have a paralegal who does most of the work, but I'm the one that's responsible for oversight, both my information and the paralegal's information has to go on. So they require, if it's up to 2 people who are participating, have to have their information go along as well. So the individual primarily responsible for directing the filing if more than one individual is involved. What we do, we are obtaining a FinCEN identifier, so we can register ourselves so that we get an ID back, and then every time we do this, and if you're in the business of helping clients and you're going to do this as well, then that's something that you can do and get an identifier that way. So if you're going to register once for your company, then I don't know that the FinCEN identifier is going to be necessarily something you would want to get. Perhaps you do, but for somebody who is going to do the company applicant for more than one person or more than one company, then that's a good shortcut, so that you don't have to input your information every time you do this. So what information has to be disclosed? Well, it's identifying information. So they're looking to find the people who are in control of the company, because the company hides that, right? So nobody knows for sure. So the government wants it to be disclosed. Who is the reporting company? So what's the who's in charge of the company? Where does the company exist? Those kinds of things. What are the details about the company? Who are the people who put it together and had it filed with the state? And who is the beneficial owner? Who's the one that controls that? So the reporting company itself, the full legal name of the company has to be disclosed, as well as any trade name. So you might see it as doing business as. In Maryland, those are called trade names. So they would have to be registered, and I believe the fee is like $25 or something like that you do. And so you can have a corporate name and or LLC name, but you're doing business as this other name. Then all of those would have to be disclosed. The current business address plus the EIN of the company. So the tax identification number has to be included as well. So the beneficial owner would also have to be disclosed. So those things would have to be disclosed regarding the reporting company, and then the company applicant. So this is the law firm or anyone else who created the entity, who other than the beneficial owner. So the beneficial owner already has to disclose this. So the individual's full legal name, so date of birth, business address, and then the government issued driver's license or passport number. Plus, you have to scan a copy into the record as well. So whatever you choose to use, whether it's a passport or a driver's license to have the identification, to use the identification, then whatever that is, the copy has to be included as well and submitted to the U.S. Treasury. And so that is the folks who are assisting, who filed the paperwork to create the entity. The beneficial owner's information that has to be included is the full legal name, date of birth, and residence address. So your personal residence, if you're an owner, that has to be disclosed to the government. You can't use the business address for this. So in your driver's license number as well, and whatever you use, the number of the passport or driver's license number, then the copy has to go along with it. So the thing to recall is that the timing of the filing depends on when the entity was created. So for all businesses that were created prior to January 1 of this year, so from December 31st of 2023 backwards, the deadline for filing this information is the end of this calendar year, December 31st of 2024. So for all companies that were formed on January 1, 2024 or later, then you have 90 days within the time that the filing occurred to provide this report. Now, starting next January, on January 2025, January 1, 2025, that 90 days becomes a 30-day requirement. So the time for compliance is shrinking. So right now, folks may be thinking, well, I've got time to do this. I don't know. Maybe you do. Maybe the mad rush at the end of the year, or maybe the penalties that'll come up afterwards. We'll talk about that a little while later. So the company applicant, any entities created prior to January 1, there doesn't have to be any filing. So as somebody who's helped folks over the last 25, 30 years do these kind of things, I don't have to go backwards and find all this information and say, oh my gosh, we did all these things over these years. And we have to, no, don't have to do any of that. It's prospective. So going forward from January 1 of 2024, that's when we have to have our information reported if we're helping form these companies. Now, it has to be included with the initial report. So that all has to happen all at once, and it's the same filing requirement time. So when the BOIR, the beneficial owner information report, is filed, then the company applicant information has to be filed with it. Some concerns, I call them observations. Beneficial owners could be not readily identifiable. So we might not know who they would be, especially if trust owns the company. They might not be readily identifiable from the terms of the trust. It could be that a class of owners, it could be that would be the folks who would be beneficial owners and in control, and we might not have them all identified. So that's something that could be a speed bump in the process.
Hey, Ed, I have a quick question for you. Let's say you're registering and then somebody moves. How often do you have to update this?
George, you are stealing my thunder and giving
sorry.
You are. So you will see a slide later on that says, it's if somebody changes their personal residence and they're an owner who previously had registered, it's a 30, if it's after next year, it's a 30-day, as soon as 30 days after you move, you've got to report that information. So it is a paradigm shift because we're used to setting it up and then going on our way and doing our business. And now the government is saying, no. You got to let us know when all these other things happen over here. These kind of things happen. And it's not things that you necessarily associate with your business.
So what happens if you don't do it?
We're getting there.
Okay. All right. Just asking.
So the concerns that the beneficial owner status can change from year to year. So you can change beneficial owners. So somebody might either gift or they may sell a portion of their ownership. The owners may wind up shifting into someone who might have been didn't meet the qualification, now does because of additional ownership interest. And so there's always something going on. Anyone who has any kind of modifications over year to year, or even over a 30-day period, you have a compliance deadline of 30 days. You make that move that George mentioned, it's a 30-day requirement after January of 2025, or actually after December, on January 1 of 2025. And so it's any information that's changed, you have to change it up in the system. So it's something that it is a new realm of compliance of sensitive information. So some potential traps is, if you have a trustee who, let's say somebody is a trustee of a trust and the trust owns, and that trustee becomes disabled and somebody else takes over for that trustee, well, then there's a change. And that person is now is potentially the owner of this company. They have management control as trustee of this trust, and so that information has to be included. And so this is something that, although oftentimes it's routinely recommended to own the company ownership within your trust and then have a special person appointed to manage the company inside the trust. If that person needs to be changed for whatever reason, the name of that person changes in that trust. Again, the trust, you think of it in one aspect, but you're not thinking of it in a day-to-day basis as the owner of the entity. That is something that could easily slip past folks. And changes, if there are committees class of people who have any type of role in whether they're advisors or whether they are some type of make recommendations, a committee of making recommendations, or it's not quite a board of directors, but a similar concept. This could be any changes in those would have to be reported potentially because they would have control as well. Minors who come of age, so that would be something that would be a potential issue because minors can't own anything. But then, if they're a potential beneficial owner, they become one at age 18. If they're named as a beneficiary, if someone passes away, but along those lines, name changes when someone gets married. It doesn't happen as much anymore these days, but it still does. And that could be a name change from a married name, and maybe the Corporate Transparency Act contributes to the dissolution of the marriage, and they shift their surname. Again, a spouse shifts their surname, and that could be potentially one. And then again, we mentioned earlier, gifting or selling. Those are issues that could pop in. And so what it's going to require is a system of how to deal with this situation and making sure that things are flagged and not ignored. Because one of the things that you can run into is these penalties. It's both a civil and criminal penalty for this. So it's money and time behind bars potentially. And it's pretty onerous. It's $500 per day for each day that the violation continues. So we talked about a 30-day reporting period starting in 2025. So if you report on day 31, then potentially that's a $500 fine. I don't know how severe they're going to enforce this, how this is going to be. I guess a lot of it depends on the election this fall. But you know, I think this is something that's been brewing for a long time, and you know, there's a lot of disdain in the Treasury for small businesses because they look at all of us like we're suspect of before we are exonerated. So I think we have to be careful about this, and we have to be concerned about how we approach this and do it seriously, and not to just blow this off as, oh, okay, you know, if I'm late, I pay a small fee or something like that. No, this is pretty substantial and pretty onerous. And the violations would be for failing to report beneficial ownership, and including changes to information previously filed. And I'll give you an example. So we're trying to close an estate, and one of the assets in the estate was a partial ownership of a corporation, and the corporation, the resident agent of the corporation, who is still listed on the state of Maryland's website, has apparently been dead for several years. Nobody made a change. And so under these new rules, that would trigger a $500 per day fine potentially for failure to do that. And I don't know how long ago that person died, but when we did the paperwork to try to get the deceased name off and the beneficiaries on, we addressed it to the resident agent, and then we got the blowback from the family saying, well, that person's dead. Why did you send it to that person? Because they're the ones who are on a damn state website. That's why. So this is something that you look through corporations and you see things that are old information, and you know, you're gonna wind up having to report that information, the proper information, to the federal government. Now, bear in mind, this is not a fine for failure to update it on the state's website. These are fines for failure to report to the United States Treasury. So it's different. And then providing fraudulent information is obviously, yeah, they don't like to be lied to. And so if you're going to lie to them, then they're going to be upset and they're going to crush you. So I think the violations of 500 a day, if they see that you're trying to deliberately mislead them, then they're going to hammer you as far as they can hammer you. So expect that. So just don't do that. Causing a company not to file or to report incomplete information. I'm not sure. I guess that's a third party would potentially violate, or an individual could be in violation. But these are all things that you got to be careful, because these are some hefty penalties, and that's what all the articles I've been reading about have been hammering on these penalties, and for good reason, because they do get enforced. The federal government doesn't mess around. When they want to come after you, they come after you hard, and it may take you years to get exonerated. So bear in mind. The next slide, we're going to talk about that. So on March 1st, the U.S. District Court for the Northern District of Alabama ruled that the Corporate Transparency Act is unconstitutional. Okay, so I guess we stop and we go home, right? We don't have to think about it. Well, it's wrong, because that order only applies to the litigants in that case. So the U.S. District Court for the Northern District of Alabama cannot rule on a constitutionality and have it spread across the United States. So it's limited only to the litigants in that case. The case has been appealed to the 11th Circuit Court of Appeals, in which Alabama is covered. So that circuit will have to take up the case. They will rule on the case, and whoever loses is going to appeal to the United States Supreme Court. So a decision is way down the road. The downside is, in order for the constitutionality to be decided for the whole United States, it's the United States Supreme Court that has to make that decision. And so that we're several years away from that anyway. So we do have the compliance rules in the meantime. And you're going to start to see others pop up and have things. And then if there's other circuits that are dealing with it, then the Supreme Court might fast track it and say, well, we have to resolve a conflict in the circuits if they rule differently. So, it's when they have different rulings, they don't like to leave those, having one area of the country have one law apply, have the law interpreted one way, and a different area of the country have it applied differently. So they want to, that may stir a little bit quicker reply, but it's still a couple years away before this finally happens. So we still have to deal with it in the meantime, and deal with the penalties. I have a feeling that folks are going to wait until December to address these issues, because that's when the deadline is, and right, everybody is proactive and gets everything done ahead of time, plenty of time. Nobody procrastinates, right? So, but yeah, we know how it works. Everybody's involved in their business and they're not thinking about it, and all of a sudden, oh my goodness, here we are, and we have this deadline and we have to deal with it. And I'm wondering,
how long does it take to complete application?
oh, it's real quick. It's not. And that's the one thing about it, is that they made it real easy to upload the information. So it's not difficult to do that. The difficulty is thinking about it and connecting it and making the updates and getting the information in. It's not actual input. It's actually a very clean website. So you enter it into a website, and it's a very clean, it's very intuitive. So it's not it's not rocket science. It's just having the infrastructure and the mentality to make sure that gets updated on a regular basis, I think, is what's going to happen.
Okay.
So as a graphical representation, so anything that was filed, any company that was created and filed with the state before January 1 of 2024, it's the beneficiary owner information report is due on the no later than December 31st of 2024, not 2014. So sorry about that. They're all going to say 2014, but it should be 2024. Yes, that's what you get when you get lawyers doing PowerPoints. So they don't teach how to do that in law school. But be that as it may, it's 2024 in that regard. So on or after January 1 of 2024, if it's filed, then you have not only those two, the beneficiary owner report, you have to provide information about the company applicant. So whatever company assisted in the formation, that's due 90 days after the creation state filing with the state. And then starting in 2025, the change is a 30-day requirement after formation. So anything formed this year, 90 days. Anything formed next year and beyond is 30 days. And anything before January 1 of 2024 is December 31 of 2024. One of the issues is that, and oftentimes this kind of information is kind of like addressed the way Ron Popeil would sell his chicken ovens, set it and forget it. Once we do it, we don't have to think about it again. But that we can't be doing that. It's important to file the information. It's not difficult to do. One of the things that that is going to require, and a lot of businesses don't do a regular review, and I think it's probably appropriate for companies to be a little bit more formal about doing a review. It could be the formalities of the company. Keeping the formalities up to date is what actually keeps the liabilities protected. Everybody forms these companies in part because they want to prevent personal liability. And a lot of times, if you neglect the formalities of the corporation on an ongoing basis, courts will interpret that you're not following the formalities, so you should not get the protection of the formalities. So it's always important to do that. We always recommend people do that. Very few people do, and we wind up following years later, keep getting things up to date, and rather than doing on a regular basis. So modifications of owner information. Owner moves personal residence must update within 30 days of the move. That's important. And so there has to be a regular prompt of, hey, when these things happen. And, it's like washing your hair, lather, rinse, repeat is how it works. The education of business owners simply means providing the information, right? Retention always comes with repetition. So you repeat it enough, and then it becomes important, and it remembers. You get the muscle memory, and your brain is the muscle here. You keep that going, and you include systems in place. So one of the things that we have in our practice for our clients is we have a database that is accessible to our clients 24/7, 365. So clients can notify of any changes that happen. We have regular prompts. So this is the first year we're doing it. So I can't say there's a track record of doing this over a period of years, but we're implementing this in our system so that clients do get regular prompts to remind them if any of this has changed, to make sure that they report it to us so that we can make sure that it gets uploaded to the website. And if not, then they can do so as well. In our world, we have long-term relationships with our clients. So this is an easy thing to implement for us. So we do it on the estate planning side and the business planning side. We're always poised to help. So we make sure, and clients have the ongoing educational opportunities. So this kind of just dovetails into what we're already doing. So in our world, if that's something that would work for you, then we would be interested in learning a little bit more about how we can help you in keeping in compliance over time with the Corporate Transparency Act. So we thank you for attending. Our next steps would be if you would complete the evaluation, the survey that being provided by email. Let us know where you stand, where you sit, what you feel, what you think. Opportunities would be to have individual conversations with folks. We do have additional educational opportunities available for that. And then you determine as a business owner your best compliance procedure. So I'm through with the slides. Any questions?
Yeah.
Concerns?
There is a question. Are 501c3 organizations exempt?
So the 501c3 organization, that is a great question, because I'm not even thinking in terms of 501c3. Off the top of my head, I would guess that they are one of those highly regulated companies that would not have to be be done, because there's much more much more to those as opposed to just the average small business. But I don't know the answer off the top of my head.
We'll get that answer to you guys.
I will definitely, that's, believe me, you'll have the answer before the end of the day, probably the end of the hour, on that one.
Awesome. Wade, do you have anything?
No, Ed, I want to thank you for your time and your knowledge on this topic. Very timely. For the listeners today, you kind of covered. We're going to send you an evaluation via email. If you have any additional questions, if you'd like a copy of the slides, if you want to reply to that email that we send you, we can get you what you're asking for.
We did get a request for the slides, so why don't we just send them out to the people that attended?
Okay. Yeah, we can do that.
Yeah, that's great. Yeah, and we're here for, Wade and I, we focus on helping individuals and corporations. We help people move forward. We focus a lot around life events and events within the businesses, change of ownership. When people are getting married or divorced, or there's a estate planning issue where someone is about, hopefully before the person passes away, we help them. But sometimes we get cases where people pass away and they need help. They just don't know what to do. So we're here for that too. So we thank you guys for being here. We thank the Ed Clay's team for everything and helping us put this together. And like I said, we're going to have more of these coming up, and we appreciate your attendance. And Ed, again, thank you for taking your time. That's awesome. And reach out to Ed. He's great. His team is great. And they do really good stuff for everybody that works with them. So.
All right. Everyone.
All right.
Yeah, no more questions. Everyone have a great afternoon.
Thank you.
Awesome.
Right.